Morning, everyone. Welcome to this talk in the King's Chamber's Young Professionals Programme. The basis of today's talk is just to run through the applications to set aside statutory demands, the procedure behind those applications, and also then to look at the substantive elements of how those applications are dealt with by the courts, and what needs to go into those applications in order to satisfy the various thresholds that are applied. I appreciate it's a fairly dry topic for a Thursday morning, but we'll try and get through it as best we can, and hopefully it will be useful to you. These slides will be available and sent out after the talk, so you'll have those for your reference afterwards. In terms of questions, I won't do questions at the end. What I prefer to do is there's a feedback form that's sent out to everyone at the end. And if you do have any questions, if you put those on there, I'll do my best to try and get round to those and answer those for you. I think it can get a bit messy trying to deal with questions in the chat at the end of the talk. So I think that's an easier way of dealing with it. So just at the outset, I'll set out briefly the requirements for the statutory demand itself, because that's the framework that gives rise to the applications to set them aside, obviously. In particular, it's section 268 of the Insolvency Act, and I've provided that there. The debtor even will be deemed to be unable to pay their debts if a statutory demand has been properly served and 21 days or 3 weeks has expired without payment, or the debt having been fully secured in the interim period. That is, unless it was served outside of the jurisdiction. In terms of the 21-day point, we'll get to that provision at Rule 10.110 a little later. It's a slightly unusual provision and unlikely to come up very often. Section 268 refers to the prescribed form for an application. That's no longer the case, in the sense that the previous rules did have a specific application form. Instead, under the 2016 rules, what you have is a requirement that all of the content set out at Rule 10.1 is included within that demand. That provision sets out in significant detail, and I won't run through it now, but it's exactly what you'd expect, and what I'm sure many of you are familiar with and aware of, in terms of the details of the debtors and the creditors, the amount of the debt, and various other provisions that have to be included. There's also a requirement in terms of where the creditor holds any security in respect of the debt, that this be declared. We'll get to that later because it applies or is relevant to one of the substantive grounds. In terms of service of the statutory demand, if practicable, it has to be done personally. Otherwise, you have to do everything to bring it to their attention. That's Rule 10.2. The practice direction of the insolvency proceedings at paragraphs 11.2 and 12.7 provide some further guidance on the steps that should be taken where it's not practicable to serve personally. And Rule 10.3 notes that a certificate of service will need to be lodged in any bankruptcy petition in respect to the statutory demand. That's the background, that's the statutory demand itself. In terms of the applications to set it aside, the procedure is a Rule 10.4 that sets out the various requirements. They're relatively straightforward. They're sort of what you'd expect. I've highlighted a few of those there on the slide. The first of which is that it must be within 18 days of service of the demand, unless served outside of the jurisdiction. What Rule 10.110 does is it provides for extensions in respect of service outside the jurisdiction with reference to the provisions of the civil procedure rules. I'm not going to get bogged down in that now. It's worth being aware of it, and that's why I've flagged it. But that's a rabbit hole that I think is probably best avoided for present purposes. Again, the information required is set out. There was previously a standard form, and that's not the case anymore, but there is the requirement for all of this information at 10.4.3. And of course, no bankruptcy petition can be presented where the application set aside it is outstanding. The time for compliance, it ceases on the date that the application is made, and then, of course, begins to run again in the event that it is subsequently dismissed. I've also flagged there at the bottom the questions of extensions of time, and we'll come on to that on the next slide. Again, the practice direction there notes that the applications can be made after the 18-day deadline for the application, for the application to set aside the demand, and that's 11.4.2. In general, I will make a couple of references to the insolvency practice direction. It's always worth being aware of. I'm sure many of you are familiar with it. It's surprising how often you see solicitors or indeed counsel focus on the rules and the Insolvency Act and neglect to look at the provisions of the insolvency practice direction, which carry a lot of weight and have quite a lot of detail, in particular to applications such as this. And it's always worth being aware of it and checking that out in respect of these kinds of applications. In terms of applications to extend time, again, the provisions of the practice direction set out some requirements and guidance in respect of making these applications. These applications are always, to extend time, are not freestanding applications. They tend to be made together with the application to set aside the demand. It's a sort of preliminary sub-application within that broader application. There are some things that need to be included. Obviously, why the extension is required, confirming that there's no bankruptcy petition outstanding, and also, as you see there, including the information in support of that application to set it aside, the substantive application itself. The court's discretion here is an extremely broad one. It is an unfettered discretion. It's under 376 of the Insolvency Act to extend time limits. And the ranking decision that I've noted there highlighted some factors that are at play here, noting the purpose of the time limit is to provide certainty to creditors and indeed to debtors. The factors that can be at play are the merits of the application itself, the reason for the extension, and the prejudice to both the debtor and the creditor and other creditors indeed, if the extension is or isn't granted. What that case also confirms and is relevant is that this is not treated as an application for relief from sanctions. The reason for that being an extremely simple one: there is no explicit or implicit sanction within that rule, within the time limit for the making of the application, and so is not an application for relief on that basis. In practice, as I'm sure many of you are aware, debtors tend to get an extremely large amount of leeway in terms of the extensions of time, so long as they can address some of those factors, can provide some reason or some substance to their application. The court tends to allow extensions of time. Obviously, the longer extension that's sought, the less likely they are to get it. But in my experience, where the application is made substantively at the same time, courts are quite willing to move past an application for an extension and see to deal with the application substantively itself. That's the procedure. That's the more technical element of it to an extent in terms of the making of the application and the requirements for the application itself. We then get to the application having been made and the hearing and the manner in which it's dealt with by the court. The first thing to note, and as I flagged there, is that the court can simply summarily dismiss an application to set aside a demand. If it's satisfied there's no sufficient cause, that can be done on the paper without a hearing having taken place. Reasons will be given for that, but it can be done where the court considers it not worth having a hearing. Otherwise, the matter will be listed for a hearing. 5 days' notice will be given to the parties in respect of that hearing. The first hearing, the court will either decide the application or adjourn it and provide for further directions. The commentary on the Insolvency Act in Doyle, Key and Curl notes that in practice, applications are normally the first hearing are normally then adjourned and listed for a longer hearing. And apart from in the most simple of cases, I think that tends to be correct. Although many first hearings are in fact listed not for a very short hearing, but rather for, I've had some which are listed for 90 minutes or 2 hours. In my experience, in those cases, the court is quite willing to try and deal with the application at the outset. It's only where the first hearing is listed for a genuinely short hearing that the matters probably can't be dealt with and do have to go off in further directions and evidence. In particular, because with that 5-day notice period, it may not be sufficient time for the creditor, for example, to provide any proper evidence in respect of the application, albeit, of course, they will have the evidence, the information that's in the demand itself. 10.5 sets out the 4 grounds on which the applications can be set aside. I appreciate this being a relatively whistle-stop talk. I'll be running through a bit of background on each of those relatively briefly. They could all, in truth, be the subject of their own talk on their own, and so I don't want to get bogged down in the weeds of extensive discussion of them. But I'll flag some sort of headline points in respect of them as we go through. Those 4 are where the debtor has a counterclaim set off or cross demand equaling or exceeding the amount of the debt in the statutory demand. The second one, and the one that I'm sure most people are familiar with or most familiar with, is where the debt is disputed on grounds that appear to be substantial. The third is in respect of security that would satisfy the debt. And the final one is the residual ground, simply that there are other grounds that the court considers mean the demand should be set aside. The first here, counterclaim set off or cross demand. As with all of them, they're relatively straightforward conceptually. What I've done there is flag a couple of points that are worth being aware of in respect of this ground. The first of which, and it is within the provision, but it's been confirmed in the case law. It's only engaged where the value of any counterclaim or set off or cross demand equals or exceeds the debt in the statutory demand. And that's relevant because it's come up in circumstances where the counterclaim set off or cross demand was not equal or in excess of the amount in the statutory demand, but was sufficient to bring the value of the demand to below the bankruptcy threshold. And what the courts have held, and I've noted the case, the Howell decision there, is that the court should not set aside a statutory demand in those circumstances because the provision isn't engaged, it doesn't equal or exceed the value of the demand. And what was highlighted there is that the question of making a bankruptcy order is very different to the question of whether to set aside a statutory demand. In those circumstances, a court may well and is probably unlikely to make a bankruptcy order in the event of a petition being issued, but that's not grounds on which to set aside the demand itself. The second point there is the most confusing element of this ground, which is this question of mutuality that's come up in some of the case law. Flagged in particular, there was a decision about 25 years ago called Hurst and Bennett, which noted that there needed to be some element of mutuality between the counterclaim set off or cross demand in relation to the debt that's within the statutory demand. It was unclear what that meant and the extent of the connection that was required. A couple of years ago, in that decision of King that I've noted there on the slide, there was a bit of clarity provided here, noting that this can mean a variety of things, and that equally the connection required for a counterclaim set off on cross demand was different in each instance. It's worth looking into that case if you do have a situation where this arises. But as a sort of headline point, what was flagged is that situations where, for example, they were of the same legal character or where the parties were acting in the same capacity, these were enough to satisfy that requirement of mutuality. There clearly needs to be some connection, and it appears that that's sufficient for that mutuality requirement to be satisfied. The second of the grounds is that the debt is genuinely disputed on substantial grounds. This is the one that I'm sure everyone is most familiar with. It's a very well-established threshold. Whether there's a genuine triable issue, it's the same threshold as you have in relation to summary judgment under Part 24. That was confirmed in that Collier decision that I've flagged there. I won't go into a lot of detail in respect of that. I'm sure that's a very well-trodden path, and I'm sure that everyone is familiar with the standards that apply in relation to that. One point I would also flag in respect of this is not on the slide, but it's worth being aware of, and again, it comes from the practice direction at 11.4.4, is that where the demand is based on a judgment, an order, a liability order, a cost certificate or tax assessment or something like that, on an application to set aside a statutory demand, the court will not look behind that order or that document and assess the validity of the debt that is attested to in that document. They will also not, as a general rule, adjourn a hearing to set aside a statutory demand if there is an outstanding application to set aside that underlying order or judgment. Now, that is stated to be as a general rule. There is some case law on the circumstances in which they might. For example, where there's some sort of manifest injustice or fraud in underlying that original order. But that provision is certainly worth being aware of. It's liability orders in particular where this can come up quite a lot, where you see delays in the magistrates' courts in respect of an application to set aside a liability order, and a statutory demand's been presented on the basis of it. There's been an application to set aside a statutory demand, but because the liability order is still standing, the insolvency courts are unwilling to set aside the demand, and on the basis that it's perceived as going behind that original order. I've also set out something on the approach to evidence here in relation to these applications. Again, as with a summary judgment, the court won't conduct a mini trial, but isn't bound to accept any evidence or assertion that's put before it. If it's inherently implausible or contradicted by contemporary documents, it can dismiss that evidence. There must be something tenable in what is put forward in support of the application. It can't just be bare assertion that is unsupported by anything else. And what is put forward must give rise to a defence to the debt that is put in the statutory demand. And I've noted the case of Macpherson there in respect of that. As I say, that's a provision that one could go on about for a very long time. I've just tried to flag the headline points in respect of it, and I've set those out there. The third of the provisions is in respect of security. As I noted earlier, there's a requirement in Rule 10.19 for information in respect of any security held to be provided in the demand itself. The court can set aside a statutory demand if that information hasn't been provided. The other point, of course, is where the value of the security equals or exceeds the full amount of the debt. Now, what this inevitably gives rise to is arguments about the value of security. Valuation evidence inevitably then comes up. The burden of showing that the debt is fully secured in the application to set aside the demand is on the debtor to adduce that evidence and to satisfy the court that the debt owed is fully secured to the creditor. And obviously the rationale for this is extremely simple. The claimant has an alternative means of enforcing the debt. The claimant is protected, the creditor is protected by virtue of the security held. And in those circumstances, the insolvency mechanisms and procedures are simply not appropriate for enforcing or pursuing that liability of the debtor. The final ground, the residual ground, as it's described as in some of the case law, is that the court is satisfied on some other grounds. It's not a freestanding mechanism in the sense that it needs to be seen in the context of the other grounds, and so one can consider elements if there are submissions in support of the other grounds that aren't enough to satisfy that on its own. They may come into be relevant when it comes to considering this ground. It's an extremely broad provision. Indeed, there's a case in which the judge has described it as quite impossible to foresee all the circumstances in which it's going to apply. That being the case, I'm not going to try and set them all out, given the futility of that task. What I have done is set out an extract from the Chan Sui decision, which tries to explain the general principle that underlies the way that this provision is approached by the courts. And that's there that the question is whether there are circumstances which will make it unjust for the statutory demand to give rise to insolvency consequences in the particular case. That question of injustice is what underlies this this provision and the manner in which it's approached. That was in respect of the predecessor to the 2016 rules, albeit it's plainly still relevant. What I have done is set out a couple of probably the most common examples where one might encounter this provision being relevant, where it's considered to be an abusive process, and I suppose as part of an abusive process, whether it's been presented in respect of an improper purpose, as one often hears in the insolvency courts. The insolvency courts are not a debt collection mechanism. And if it's considered that it's being pursued to put pressure to, in the sense of seeking to, the boundary between debt collection and insolvency proceedings is obviously blurred, but that where there's no genuine intention to pursue a bankruptcy order in the event that no payment is made, then the court may consider it to be an improper purpose. Equally, where it's considered that the bankruptcy order will be of a disadvantage in general to the creditors, then the court may set aside the demand on this ground. I've noted the Maud and Arbar Block decision there, which noted, which sets out in paragraph 29 the question of disadvantage to creditors and the circumstances where that might be appropriate. I appreciate that was a fairly whistle-stop talk through the various provisions in respect of set-aside applications. As I say, one could go on for a very long time about each of those. What I've done there is just highlighted some of the practical points that I think are relevant as well. As I said earlier, that the practice direction is always worth considering for all insolvency applications, really, but certainly in respect of set-aside applications. If the application is unsuccessful, the order dismissing the the application will usually one will include a provision allowing the creditor to issue a bankruptcy petition on the basis of that demand. As I noted earlier, in respect of one of the grounds, the threshold is different for a statutory demand on a bankruptcy order. The bankruptcy order is a broader consideration of whether a bankruptcy order should be made. The statutory demand and setting aside a statutory demand has quite precise requirements on those four grounds that we've run through just now. And as I put at the bottom, that may seem really obvious that when making an application, it's advisable to provide as much detail as possible. It always astonishes me how often you see debtors attend at a hearing to set aside a statutory demand, making further detailed submissions and seeking to rely on various other evidence that simply isn't within their application. And the courts are sometimes simply unwilling to engage with that, where the information, all those bases haven't been set out in the application in the first place. So that may seem extremely obvious, but it's worth flagging, I think. So I hope that's been useful. It's obviously been a relatively quick run through of the procedure and the substance. As I said at the start, there's a feedback form that I understand is sent out. If you do have questions, feel free to put them on there. And as I say, I always try and get round to those and answer those as quickly as I can. Sometimes I don't go around to all of them, but I do try, and I will try and answer any questions that you might have. So those will be sent to me, and I'll try and deal with them as quickly as possible. So thank you all for attending, and I hope you have a good rest of the day.